Your Honor, I'm here appearing as a special appearance to challenge the sufficiency of the court.
What you're about to see is one of the most unbelievable courtroom showdowns you can imagine. At first, it looks like a simple traffic case, but it quickly turns into something much bigger and much stranger. A man walks into court without a lawyer, without witnesses, and without any real defense evidence. Instead, he comes armed with sovereign citizen arguments, constitutional claims, legal buzzwords, and even theories about capital letters and names. The driver, Lloyd Eugene Kleinberger, was caught on camera making an illegal right turn at a red light in Poso. The city has dashcam footage, a matching license plate, and a $145 ticket ready for him to pay. But Lloyd refuses to back down. During the hearing, he challenges everything. He questions Miranda rights in a civil traffic case, claims his name written in capital letters is not legally valid, and even argues that Dunn and Bradstreet proves the city operates like a business with a financial interest in convicting him. Meanwhile, the judge stays calm, focused, and incredibly patient as the arguments become more and more unusual. What follows is a perfect example of how quickly a courtroom can spiral when someone relies on internet legal theories instead of actual law. At the same time, it's also a lesson in how a judge handles chaos while keeping complete control of the courtroom. Stay until the end, because this case only gets crazier from here.
So what I'm going to take into consideration here is Exhibit A. Let me make this large enough so that you can see it. Basically, these photos, I am looking for a Honda Accord 2003 with a license plate of CMC 6336. This first picture usually is to identify if you can, usually I can make this bigger. If you can see here, the lights are red. The suspected vehicle is well behind the red line at the time that the traffic control devices have illuminated in red, so the vehicle has not passed the stop line at the time of the red light. The vehicle is in the far right turn lane. Looking at the license plate, CMC 6336, yes. And then finally the video clip, which we can see much larger. And so the light is red. The vehicle approaches. No stopping whatsoever. And the vehicle then continues to the right. All right, sir. I find a sufficient basis that the city has so far shown that there is a preponderance of the evidence, but I'll turn to you. Do you have any motions or testimony you'd like to offer in defense of the alleged infraction?
No, sir. I'm not the defendant.
Okay. Do you have anything else to add? You've subpoenaed the officer. Do you need to swear them in, have any testimony for them, or any other reasons to have him here?
Yes, I have questions for him.
Okay. So can you give me an offer of proof of what your intended line of questioning is?
I'm sorry, I'm not sure exactly what you mean by that.
Well, give me an example of the types of questions you want to ask so that I can make a determination as to whether or not they're relevant to this proceeding. In other words, are you going to ask him questions about how he came to the determination or what he observed or anything that he would have personal knowledge to?
I have a lot of questions about determining the validity of his charges.
Well, that's my job, sir. And so you can speak to me about that. Do you have something more?
I do, but I'm trying to figure out how to state it.
I'm sorry, just go ahead and give me an example, sir. That's okay. And then if it's something that falls within the scope, I can swear him in and let you ask that question.
All right. The first question is, Officer Kelly.
Well, ask me. You're letting me know what you're intending to ask.
I would like to ask him if he read the discovery and interrogatory, and has he had time to read it and consider it, and did he submit any answers?
Okay. So are you alleging that there's an interrogatory that was attempted? In other words, why would he have knowledge of an interrogatory? This is an infraction hearing, so interrogatories are not allowed under the rule. So I can't imagine that he's answered that.
Okay, I filed it with the court.
Oh, I know you filed it,
Yeah.
but it's not permitted. There's no rule that allows interrogatories in an infraction. So I need to find the relevance of that line of questioning. Interrogatories are not allowed under the infraction rules. So I would anticipate that the answer is going to be no, but I'm not even sure he would be aware that there was an interrogatory. So I'm gonna decline to allow that question. It's not within the scope of this hearing.
Okay, let's stop for a second because the judge just shut down 3 different motions back to back, and each decision makes complete legal sense once you understand the context. First, the interrogatories issue. Those are written questions usually used during discovery in larger legal cases. But this wasn't a criminal trial or a major lawsuit. It was a simple civil traffic infraction, basically just above the level of a parking ticket. In this type of hearing, interrogatories are not part of the process, so the judge denied it immediately. Second, the Miranda rights argument. Miranda protections only apply when someone is in police custody and being questioned in a criminal case. A traffic camera citation does not fall into that category at all, so that claim had no legal basis here. Third, the all capital letters argument. This is one of the most common sovereign citizen claims. The idea is that a name written in capital letters on legal documents represents a fake corporate identity instead of the real person. Courts across the country have repeatedly rejected this theory, and judges do not recognize it as valid law. What stands out most here is how calmly the judge responds to every argument. No anger, no sarcasm, just clear rulings and steady control of the courtroom. But now the hearing is about to take an even stranger turn because Lloyd is preparing to challenge the legitimacy of the government itself. Be honest, have you ever seen someone file this many motions in a single traffic hearing?
I'd also like to ask how he feels about the U.S. Constitution, the Washington State Constitution, and my rights under the Constitution.
Sir, I would not find that relevant. The officer would most likely testify that he has taken an oath to uphold the very same, and that's why he holds the job that he does. I don't see his feelings when it's up to me to interpret the law. That would be something that would not be within, it wouldn't be relevant to this hearing. Go ahead, sir.
I'd like to know if Officer Kelly or anyone informed me of my rights to the Miranda rights to remain silent and not testify against myself.
All right, very well, sir. Do you believe that the Miranda rights appear that they apply here in an infraction style hearing, a civil hearing that is not one that you can lose your liberty or were ever taken into custody? Do you believe that the Miranda rights are required here?
I guess I would, yes.
Okay, I will let you know that they don't. It's an infraction, so that would not be a relevant question, sir. You're not entitled to Miranda advisements. Go ahead. So I'm going to decline to allow you to ask that question.
Okay, Officer Kelly.
But just a second, it's Officer Keller, but that's okay.
Okay. Officer Kelly, he initiated a claim in the Paulsville Municipal Court. And
when you say claim, I need that's a term of art. What do you mean by a claim?
Proceeding.
What?
Proceeding.
Yeah.
Well, you've been cited for a violation of a law that's called a notice of infraction.
Okay.
Is that what you're speaking to?
I guess that is, yes.
Okay, go ahead.
Okay. When he did it, on the information that I got, it was to Janet Louise and Lloyd Eugene Kleinberger, all in capital letters. And Janet Louise and Lloyd Kleinberger in capital letters do not exist. So I would move that this case be dismissed.
Motion is denied. You've responded that you are Lloyd Eugene Kleinberger. You are appearing here today. Is that correct, sir? And you've identified yourself as that name? Because if not, I can't hold these proceedings.
A free man.
Are you Lloyd Eugene Kleinberger?
No capital letters, a free man, yes.
Absent the conditions, if you're responding under that name, then you can sit there and respond because you're that person. But if you're not that person, then you cannot hold this hearing. You're not an attorney. You can't practice law for somebody else. So I just want to be clear for the record. Are you, without conditions, Lloyd Eugene Kleinberger? Notice I'm speaking verbally, so there are no capital letters. Would you like more time to think about that answer, sir? I do have 2 other matters that still need to proceed today, because it would be incorrect for me to proceed if you are not, in fact, Lloyd Eugene Kleinberger.
All right. I am Lloyd Eugene Kleinberger.
Okay, thank you, sir. So I will deny that motion based upon the evidence presented by your affirmation of your name. Go ahead, sir. Do you have any other motions?
For you, who is the plaintiff in this case?
The city of Paulsville.
When I got the paperwork, I believe Officer Kelly did not indicate a plaintiff. And the paperwork also shows other the Paulsville Police Department as an additional plaintiff, so it's confusing.
I will take that as a motion to dismiss for improper notification. I would find that the notice of infraction that is in the record is sufficient. You, the named party, are appearing. You are made aware of the matter, date and time, and all the information, and all of the discovery was supplied to you via electronic means for which you've already admitted that you have reviewed. So the notice of infraction was sufficient to put you on, shall we say, sure enough footing to be able to appear when necessary, be notified of the charge, notify you of the potential imposition of $145. So I will deny that motion.
Your Honor, I'm here appearing as a special appearance to challenge the sufficiency of the court.
I just want to be clear. You're challenging the sufficiency of the court or the sufficiency of the evidence being presented by the city in this court? There's two different approaches. I want to make sure I'm taking the correct one.
Please restate that.
You have said that you are challenging the sufficiency of the court. I want to make sure that I understand that motion. So I'm asking for clarification. I'm asking you to clarify. Do you mean that you are challenging the sufficiency of the evidence in this court? Or are you challenging the sufficiency of this court in general? In other words, its reason for being, its ability to be. Because those are two different responses. And I just want to answer correctly.
I believe that's the court in general.
Right. I will deny that. This court is established not only through court rules and the proper statutory authority as a court of limited jurisdiction sufficiently operating in the state of Washington. So that is denied, sir. Do you have any other questions or any other motions you'd like to make, sir?
Based on what you said, I believe you would deny any other questions I have.
No, sir, I'm trying to make sure. I'm sorry that you feel that way. I'm trying to handle these as appropriately and individually as they are presented to me. Please do not take the fact that you've lost all of them as an indication that you will lose all of them if asked. I'm taking them one by one as any disinterested magistrate should do. And if you have any other motions, please, without any type of penalty, please go ahead and make those. Otherwise, I do need to move forward.
Considering that Dun and Bradstreet lists the city as Paulsville, a profit corporation doing business as municipal court, also a for-profit corporation. Dun and Bradstreet also indicates that the city of Paulsville is doing business as the police department for profit. Does that produce a conflict of interest, seeing as how everybody is working for the same corporation?
Is that question to me, or is that the one that you want to give to Officer Keller?
I would have asked Officer Kelly that, but based on what we have been talking about, I guess I'm addressing it to you.
Okay. Quick civics lesson. Oh, hang on.
Be fine too.
Well, you've addressed it to me, so let me go first. Over there are the legislative chambers. That's the first branch of government, the legislative branch. They're the ones that get together. They discuss what they want to implement. They do so through municipal code. Once they have agreement, after listening to the public, they enact municipal code. Those codes or ordinances are then sent to the executive branch. And I'm pointing over here because there's the police department, and up on the third floor is the mayor's office. That's the executive branch. They're the ones that then take the power that they were granted by the legislative branch to execute those ordinances and any adopted state statutes. That executive branch then does their own investigation. They act under the authority for which they were granted, and they make their decisions. The third branch, for which you're seated in today, is a separate branch. That's the judicial branch. I am the head of that judicial branch. I am the presiding judge in this court. Yes, Paulsville, Dun and Bradstreet, and however that may affect how you think this should be answered, Paulsville Municipal Court is an entity of the Paulsville Municipal Government, and I am a disinterested third branch, not related to the executive branch, not related to the legislative branch. That is why you have a hearing today, because the city, through its executive branch, the police department, has given you a notice of infraction. The government has said, we believe that you violated an ordinance and therefore you are going to be fined. You can pay it. You can request a hearing. You've requested a hearing. That then goes to my branch, where I hold a fair and impartial hearing, where the city brings their representative that you have subpoenaed, and I will hear from both parties to be able to interpret the law, which is my job. So whether that poses a conflict, I would have to say it does not, unless you've seen something specific that leads you to believe that I am conflicted in hearing your matter. Per se, I am not conflicted in any way, sir. You said you wanted to ask the officer that question?
That was my original intent.
Okay, so let's say he believes there is a conflict. What remedy? Let's just take this to its logical end. What remedy do you believe that you would be entitled to, even if he said, yes, because I work for the city, I would... Is a conflict different than bias? I'm not sure of what question you're asking. Because he's a fact witness. So are you saying he's conflicted because he has personal knowledge and works for the city?
Not knowing the nice gentleman, there could be that position where he thinks that it's best for the city to find people.
Oh, to find people. All right, sir. If you want to ask, because I think that falls a little bit more into bias, which would be relevant to the officer's understanding and formation of his mind in bringing a potential charge. I think that that would be relevant under bias. Do you want me to swear him in to allow that question to be asked?
Sure.
Officer Keller, this time, can I have you raise your right hand, please? Do you swear or affirm the testimony you're about to give in this matter is the truth and nothing but the truth, sir?
Yeah.
All right. Having been sworn in, sir, I'm going to allow Mr. Kleinberger to ask you a question. Go ahead, Mr. Kleinberger, if you'd like to ask that question.
Do you feel because of the relationship between the police, the municipal court, and the Paulsbo, that there's any possibility that you would have a bias in trying to bring in more money for the city?
No, sir.
All right. Any further questions?
I guess not.
All right, sir. Would you like to make any presentation of evidence or have any witnesses sworn in defense?
No, sir.
All right. Thank you. Then I'm going to release the witness. All right.
That's fine.
All right.
Thank you.
Thank you, Officer Keller. You are hereby no longer under oath and free to go about your day. All right. Mr. Kleinberger, if there's no further argument, I'm going to take the evidence that was presented by the city. I do find by a preponderance of the evidence that the infraction was in fact committed by the registered owners. There's a presumption in the law that the registered owners are the drivers. I've heard no testimony that overcomes that presumption, and therefore I will find it committed and impose the amount of $145. You have 30 days to pay. If you need more time, you can set up a free payment arrangement. The good news is, if there's any to be had today, sir, is that this is, even though you were, the driver was in motion, this is not considered a moving violation. So it will not be reported to insurance and will not be used in that way because it does not go to Department of Licensing. The law requires these to be treated in the same vein as a non-moving parking ticket. So it will not have that secondary effect. But the $145 will be imposed as a result of the finding of committed today based upon the presentation of evidence. Once you have your order, sir, you are free to leave. If you want to set up payment arrangements, you can do so upstairs. All right.
Can I ask you what evidence you have that I was driving?
You can review the record, sir. I don't have to show any evidence that you were driving. The law has a presumption in there that the registered owner is the driver, and that's why I made the finding that you did not overcome that rebuttable presumption. All right, that'll conclude the hearing, sir. Thank you.
And there it is. And just like that, the case comes to an end. Lloyd Eugene Kleinberger, the registered owner of a 2003 Honda Accord with license plate CMC 6036, is officially found responsible for running a red light. The penalty? A $145 fine. The one piece of good news for Lloyd is that, under Washington state law, red light camera tickets are considered non-moving violations. That means the citation will not appear on his driving record and should not impact his insurance rates. In other words, it's handled more like a parking ticket than a serious traffic offense. To his credit, Lloyd clearly came to court ready to fight. He challenged the court's authority, questioned jurisdiction, referenced constitutional rights, and even tried using Dunn and Bradstreet records to support his arguments inside a municipal courtroom. But in the end, none of those claims overcame the actual evidence. The traffic camera footage was clear, the license plate matched, and a legal assumption that the vehicle owner was driving was never successfully disproven. Throughout the hearing, the judge stayed calm, professional, and patient while addressing every argument one by one. So now the big question is this: did Lloyd raise any legitimate concerns during the hearing, or was this case doomed from the moment it began? Share your thoughts in the comments below. And if you enjoyed this courtroom breakdown, don't forget to like the video, share it with someone who would find this unbelievable, and subscribe for more courtroom moments that are just as wild as this one. Because trust us, there are plenty more cases like this coming soon.